Okay, hello. Hello sa dalawang likers na nag-like agad Hello sa inyo. Anyway, nandito na naman si Lolo Ray para magbigay na naman ng kanyang babasahin. Magbabasa na naman ako ng batas. Okay. Natapos na kasi natin last time yung civil procedure, ano? Kung nung nakaraan, pinag-aralan natin yung civil procedure, binasa-basa natin yung rules on civil procedure at ginagamit itong rules na ito sa korte kung ikaw ay may basihan yung action mo para ireklamo mo ang kabila o merong kang karapatan ng dahil sa isang mali na aksyon ng kabilang partidos o ng dahil sa hindi niya pagkilos. At ang mga paglabag na ito ay hindi naman masasabing krimen dahil hindi naman ito nakalagay sa revised penal code o hindi naman ito wala namang special law na pinaparusahan ito. Yung mga agawan sa lupa, away sa lupa, ito po ay yan yung mga examples natin ng civil na mga pangyayari kung saan civil cases, civil procedure ang ginagamit. Yun yung napag-aralan natin last time, yun yung binasa natin last time na hopefully ay may natutunan tayo pare-pareho. Ako hindi ko na naalala yung binasa ko. Pero ngayon magtutungo naman tayo sa special proceedings. Tama ba? Okay, tama. Special proceedings, ano? Etong special proceedings na ito, saan naman ginagamit ito mga ito? Ba't ang dami namang proceedings? Di ba pwedeng iisa na lang? Wala po Merong itinakda yung korte ng mga paggagamitan ng special proceedings. At nagsisimula po ang provision sa librong Rules of Court ng Special Proceedings sa Rule 72. Basahin natin. Sabi rito, Subject Matter and Applicability of General Rules. Section 1. Subject Matter of Special Proceedings. Rules of Special Proceedings are provided for in the following cases. Unang-una sa settlement daw ng estate. Settlement of estate of deceased persons. Settlement ng ari-arian na naiwan ng isang namatay. Letter B, escheat. Pwede natin i-define yan mamaya. I-define na natin ngayon. Kaya mabilis, escheat. Ganda sana kung may researcher ako no? Hanapin mo nga yung escheat. Ito. Kunin na natin yung definition ng Investopedia. What is escheat? Escheat refers to the right of a government to take ownership of estate assets or unclaimed property. It most commonly occurs when an individual dies with no will and no heirs. Escheat rights can also be granted when assets are unclaimed for a prolonged period of time. These situations can also be referred to as bona vacantia or simply just unclaimed property. So yun ang ibig sabihin ng escheat daw. Saan yung gobyerno ay maaaring kunin ng isang ari-arian ng isang taong namatay na walang mga legal na tagapagmana. Okay? So, ginagamit yung special proceedings kapag yun, settlement of estate of deceased, number 1. Letter B, escheat. Letter C, guardianship and custody of children. Letter D, trustees. Letter E, adoption. Letter F, rescission and revocation of adoption. Letter G, hospitalization of insane persons. Letter H, habeas corpus. Letter I, change of name. Letter J, voluntary dissolution of corporations. Letter K, judicial approval of voluntary recognition of minor natural children. Letter L, constitution of family home. Letter M, declaration of absence and death. And letter N, cancellation of correction of entry. Or, siguro ito, nagkamali lang siya. Cancellation or correction of entries in the civil registry. Correction of entries. Okay. Sabi niya rin dito, in the absence of special provisions, The rules provide for in ordinary actions shall be, as far as practicable, applicable in special proceedings. Okay, so pwede nito gamitin yung binasa natin dati, yung ordinary, yung rules for ordinary civil actions kung walang specific na nakasaad para dito. Pero kasi nilinaw niya dun sa binasa natin kung saan siya gagamitin eh. Itong rules na ito, di ba? So may special rules, mayroong special proceedings for special occasions. Charot. Para sa mga nabanggit. Magpunta tayo sa settlement ng estate ng isang namatay o namayapa na tao. Settlement of estate of deceased persons, Rule 73, venue and process. Where the estate of the deceased persons, yun ang yun ang ibig niya sabihin. If the decedent is an inhabitant, yung mga nalilito na ako. If the decedent, yung namayapa yata ito, is an inhabitant of the Philippines at the time of his death, ayun, tama nga. Whether a citizen or an alien, he shall be proved or letters of administration granted, and his estate settled in the court of first instance in the province in which he resides at the time of his death. And if he is an inhabitant of a foreign country, the court of first instance of any province in which he had estate or pag-aari. The court, first taking cognizance of the settlement of the estate of a decedent, shall exercise jurisdiction to the exclusion of all other courts. The jurisdiction assumed by a court, so far as it depends on the place of residence of the decedent or of the location of his estate, shall not be contested in a suit or proceeding except in an appeal from the court in the original case or when the want of jurisdiction appears on the record. Ay, tungo naman tayo sa Section 2. Saan naman daw? Where estate settled upon dissolution of marriage. When the marriage is dissolved by the death of the husband or wife, nadi-dissolve, ibig sabihin wala na yung na-dissolve, natunaw na yung kasal sapagkat namatay. Example dito ng pagkatunaw ng kasal, yung namatay. Hindi na sila, parang korporasyon nadi-dissolve pagka nabuwag na ito, parang ganoon din yun, namatay yung asawa mo, balo ka na. Di ba nga, pwede ka na mag-ikasal ulit, sabi. So sabi lang dito, when the marriage is dissolved by the death of the husband or wife, the community property yung pinagsamang ari-arian nila shall be inventoried, administered, and liquidated, and the debts therefore paid in the testate or intestate proceedings of the deceased spouse. If both spouses have died, the conjugal partnership shall be liquidated in the testate or intestate proceedings of either. Section 3, yung proseso raw, the process. In the exercise of probate jurisdiction, courts of first instance may issue warrants and process necessary to compel the attendance of witnesses or to carry into effect their orders and judgments and all other powers granted them by law. If a person does not perform an order or judgment rendered by a court in the exercise of his probate jurisdiction, it may issue a warrant for the apprehension and imprisonment of such person until he performs such order or judgment or is released. Okay? Mas mahalagang tandaan, pag inutusan ka ng korte, sumunod ka kasi pwede ka makulong. Section 4, presumption of death. For purposes of settlement of his estate, a person shall be presumed dead if absent and unheard from for the periods fixed in the civil code. Nakalagay ito sa civil code. But if such person proves to be alive, he shall be entitled to the balance of his estate after payment of all his debts. The balance may be recovered by motion in the same proceeding. Okay? So, malinaw naman yung sinasabi ron. Meron kasing tinatawag sa civil code na presumptive death. Merong period na tinakdaan ng batas, di mo na alam kung saan na ba yung asawa ko, ano bang whereabouts niya. Pwede ka mag-file yata ng presumptive death. So, kinakailangan din yun para masettle yung estate ng taong yun. Pero sakaling buhay naman daw siya, yung taong pinresume na patay pero buhay naman, shall be entitled to the balance of his estate matapos bayaran ng estate na yon yung mga utang nila. Okay? Rule 74, summary settlement of estate. Section 1. Extrajudicial settlement by agreement between heirs. If the decedent left no will and no debts, and the heirs are all of age, or the minors are represented by their judicial or legal representatives duly authorized for the purpose, the parties may, without securing letters of administration, divide the estate among themselves as they see fit by means of a public instrument filed in the office of the Register of Deeds, and should they disagree, they may do so in an ordinary action of partition. Ayan. If there is only one heir, he may adjudicate to himself the entire estate by means of an affidavit filed in the office of the Register of Deeds. Kung iisa ka lang, wala ka namang ibang kahati sa mana, pwede mong i-adjudicate o desisyonan para sa sarili mo yung pag-aari na yon sa Register of Deeds. The parties to an extrajudicial settlement, whether by public instrument or by stipulation in a pending action for partition, or the sole heir who adjudicates the entire estate to himself by means of an affidavit, shall file simultaneously o kasabay daw with and as a condition precedent to the filing of the public instrument or stipulation in the action for partition or of the affidavit in the office of the Register of Deeds, a bond. Pa-file na naman ng bond, ha? May karampatang halaga with the said Register of Deeds in an amount equivalent o katumbas ng value of the personal property involved as certified to under oath by the parties concerned and conditioned upon the payment of any just claim that may be filed under Section 4 of this rule. It shall be presumed that the decedent left no debts if no creditor files a petition for letters of administration within 2 years after the death of the decedent. Okay. Section 2, Summary Settlement of Estate of Small Value. Okay, maliit lang daw ang halaga ng naiwang pag-aari. Whenever the gross value of the estate of a deceased person, whether he died testate or intestate, ibig sabihin whether daw namatay siya na may will o wala, does not exceed 10,000 pesos, and that fact is made to appear to the court of first instance having jurisdiction of the estate by the petition of an interested person, and upon hearing, which shall be held not less than 1 month, nor more than 3 months from the date of the last publication of a notice, which shall be published once a week for 3 consecutive weeks in a newspaper of general circulation in the province, and after such notice to interested persons as the court may direct, the court may proceed summarily, without the appointment of an executor, administrator, and without delay, to grant, if proper, the allowance of the will, if any there be, to determine who are the persons legally entitled to participate in the estate, and to apportion and divide it among them after payment of such debts of the estate as the court shall then find to be due, and such persons in their own right, if they are lawful age and legal capacity, or by their guardians or trustees legally appointed and qualified, if otherwise naman daw, shall thereupon be entitled to receive and enter into the possession of the portions of the estate so awarded to them, respectively. Ang haba na naman ng period. The court shall make such order as may be just, respecting the costs of the proceedings, and all the orders and judgments made or rendered in the course thereof shall be recorded in the office of the clerk, and the order of partition or award, if it involves real estate, shall be recorded in the proper register's office. Tungo naman tayo, Section 3. Bond to be filed by the distributees, yung mga pagbibigyan, okay? The court, before allowing a partition in accordance with the provisions of the preceding section, may require the distributees, if property other than real is to be distributed, to file a bond in an amount to be fixed by court, condition for the payment of any just claim which may be filed under the next succeeding section. Okay. Section 4, ano ba yung mga liability of distributees and estate? Sabi rito, if it shall appear at any time within 2 years after the settlement and distribution of an estate in accordance with the provisions of either of the first 2 sections of this rule, that an heir or other person has been unduly deprived of his lawful participation in the estate, Such heir or such other person may compel the settlement of the estate in the courts in the manner herein after provided for the purpose of satisfying such lawful participation. And if within the same time of 2 years it shall appear that there are debts outstanding against the estate which have not been paid, or that an heir or other person has been unduly deprived of his lawful participation payable in money, the court having jurisdiction of the estate may, by order for that purpose, after hearing, the court may settle the amount of such debts or lawful participation and order how much and in what manner each distributee shall contribute in the payment thereof, and may issue execution, if circumstances require, against the bond provided in the preceding section or against the real estate belonging to the deceased or both. Haba, no? Such bond and such real estate shall remain charged with a liability to creditors, heirs, or other persons for the full period of 2 years after such distribution, notwithstanding any transfers of real estate that may have been made. Ayan, no? Napakasalimuot ng batas, no? Kaya may mga ganitong medyo masasalimuot na mga pangyayari, merong itinakda ang Korte Suprema na special proceedings. Ayun, di ba? Section 5, period for claim of minor or incapacitated person. If on the date of the expiration of the period of 2 years prescribed in the preceding section, the person authorized to file a claim is a minor, isa raw siyang minor de edad o isa siyang mentally incapacitated o kaya naman nasa kulungan siya outside the Philippines, he may present his claim within 1 year after such disability is removed. Okay? Magtungo naman tayo sa Rule 75. Di ba? Ang daming batas, no? Basahin mo pa lang, ang hirap na, unawain pa. Binabasa ko sa inyo para hindi na kayo mamili ng libro. O di ba? Pag gusto nyo magkaroon ng idea sa batas, pakinggan nyo na lang to. Production of will, allowance of will necessary. Section 1 ng Rule 75. Allowance necessary, conclusive as to execution. Wala raw will shall pass either real or personal estate unless it is proved and allowed in the proper court. Subject to the right of appeal, such allowance of the will shall be conclusive as to its due execution. Allowance ng will, ibig sabihin, pinapahintulutan na makapangyayari yung iniwan na will. Yan yung alam nating last will and testimony. Yan yun, in layman's terms. Ano po? Section 2. Custodian of will to deliver. The person who has custody of a will shall, within 20 days after he knows of the death of the testator, deliver the will to the court having jurisdiction or to the executor named in the will. Kasi merong pinapangalanan dun sa will na executor. Diba? So, pwedeng dadalhin nung may hawak nung written yung will na yan doon sa executor o di naman idiretso niyang ibigay sa korte. Section 3, executor to present will and accept or refuse trust. Diba? Hirap unawain. A person daw na pinangalanan or named as executor in a will shall within 20 days after he knows the death of the testate or within 20 days after he knows that he is named executor, if he obtains such knowledge after the death of the testator, present such will to the court having jurisdiction, unless the will has reached the court in any other manner, and shall within such period signify to the court in writing his acceptance of the trust or refusal to accept it. Yun po ang ibig lang sabihin nun. Pag daw ikaw, inassign ka na executor, tapos within 20 days na malaman mo na namatay o pumanaw na yung gumawa ng will na yon, yung may-ari may-ari ang naiwan, dapat daw within 20 days, matapos mo malaman yung kanyang kamatayan, magpunta ka na sa korte. Or 20 days after mong malaman na ikaw yung executor doon sa will. Diba? Pinakamaganda, pumunta ka agad. Yun ang pinakamaganda kasi yung utos ng batas para walang masyadong hassle. O, diba? Section 4, custodian and executor subject to fine for neglect. A person who neglects any of the duties required in the last two in the two last preceding sections without excused satisfactory to the court shall be fined not exceeding 2,000 pesos. Siguro ito mas malaki na. Baka hindi na 2,000 pesos ngayon. Pero base po dun sa lumang rules of court na binabasa natin, yun ang halaga. Kasi po kung ikaw ay custodian ng isang, in layman's terms, last will or testimony, yan. O hindi naman kaya ikaw ang executor, meron po kayong panunungkulan, 'di ba? Na kailangan mong tuparin, 'di ba? Kundi ikaw ay karapat-dapat parusahan. Section 5, person retaining will may be committed. So a person daw having custody o siya may hawak ng will after the death of the testator. Yung testator po yung gumagawa ng will, who neglects without reasonable cause to deliver the same when ordered so to do, to the court having jurisdiction, may be committed to prison and there kept until he delivers the will. So kung ikaw sinungaling ka o di naman ayaw mong i-deliver yung will kasi nagagalit ka dun sa mga makikinabang sa will, pwede kang ipakulong. Okay? Rule 76, allowance or disallowance of will. Section 1, who may petition for the allowance of will? Sino raw magpepetisyon ito para makapangyari yung will? O in layman's term nga, yung last will and testimony. Any executor daw, devisee or legatee named o ipinangalanan doon sa will na yun, or any other person interested in the estate may at any time after the death of the testator petition the court having jurisdiction to have the will allowed, whether the same be in possession or not, or is lost or destroyed. The testator himself may, during his lifetime, petition... tutumba na naman, nahila ko na naman. The testator himself may, yun daw gumawa ng will. Bakit ang laki ng mukha ko? Yan. Uy, wow. Yan. During his lifetime, petition the court for the allowance of the will. So kahit pala nabubuhay pa yung gumawa ng will, pwede na siya magpetisyon na payagan makapangyari ang kanyang last will and testament. Section 2, contents of petition. A petition for the allowance of a will must show so far as known to the petitioner. Letter A, the jurisdictional facts. Ayan. Letter B, yung daw mga pangalan, name, ages, and residences of the heirs, mga tagapagmana, legatees, and devisees of the testator or decedent. Letter C, the probable value and character of the property of the estate. Letter D, the name of the person for whom letters are prayed. Letter E, if the will has not been delivered to the court, the name of the person having custody of it. But no defect in the petition shall render void the allowance of the will or the issuance of letters testamentary or of administration with the will annexed. Yun ang sinasabi niya. Hindi naman daw ibig sabihin may defecto yung will, void na ito kaagad. Hindi na ito papayagang makapangyayari. Hoy, Pernan ha, shout out ko lang si Pernan at si Elaine ha. Kayong dalawa, mag-aaral ba kayo talaga ng law? At gusto yung basahin ko to ha. Pero hopefully nakakatulong sa inyo sa mga ordinaryo nating kababayan, no? Section 3, court to appoint time for proving will. Notice thereof to be published. Yun ang pag-uusapan natin sa Section 3. Sabi rito, when a will is delivered to or a petition for the allowance of a will is filed in the court having jurisdiction, such court shall fix a time and place for proving the will when all concerned may appear to contest the allowance thereof, and shall cause notice of such time and place to be published 3 weeks successively. Sunod-sunod yan. 3 weeks, ipapapublish niya yan. Previous to the time appointed in a newspaper of general circulation in the province. Doon sa probinsya nyo, kailangan yung newspaper of general circulation. Ipag-utos ng korte, hindi korte ang magbabayad niya na yung nagpapa-allow, yung nagpepetisyon na makapangyari yung will, yun ang magbabayad niyan. Pero wala raw, no newspaper publication shall be made where the petition to probate has been filed by the testator himself. So kung yung testator, nabubuhay pa siya ang nagpetisyon, hindi na raw yata kailangan tong newspaper publication. Wala na raw ganun. Section 4, bakit ano palang lohika ng mga ganyan? Bakit hindi na kailangan pag yung ang nagpetisyon nito yung testator o yung gumawa ng will? Kasi buhay pa siya eh. Alam niya yung mga gusto niyang pamanahan. Alam niya rin yung mga pinagkakautangan niya. Okay. Ang will, kapag ka yung executor na ang nagpetisyon nito o yung mga device o yung mga tagapagmana doon sa will na yon, syempre baka merong hindi makaalam. Baka merong isinaad roon na hindi niya alam na sa ibang lugar siya. That is why nire-require ang publication para ipaalam ito sa buong mundo na namatay na si ganito at baka meron kang karapatan doon sa ari-ari ang iniwan niya. Yun po ang lohika nun. At para ipagbigay alam din sa mga pinagkakautangan ng namatay na, oops, bago natin paghati-hatiin to, bago natin sundin yung mga nakalagay sa will mo, kailangan muna natin na ipaalam sa mga pinagkakautangan mo. Kawawa naman sila, di ba? Di ba? Hindi ka nakabayad sa utang mo, di kukunin ito sa ari-ari ang iiwan mo. Kaya sa atin, no, pagka tayo nagkaroon ng anak o pamilya, maganda mamamatay sana tayo kung maaari lamang na wala tayong utang para walang problema yung mga anak natin, no? Section 4, heirs, devices, legatees, and executors to be notified by mail or personally. The court shall also cause copies of the notice of the time and place fixed for proving the will to be addressed to the designated or other known heirs, legatees, and devices of the testator resident in the Philippines at their places of residence and deposited in the post office with the postage thereon prepaid at least 20 days before the hearing, if such places of residence be known. Period. Whew. A copy of the notice must in like manner be mailed to the person named as executor, if he be not the petitioner, also to any person named as co-executor not petitioning, if the places of residence be known. Personal service of copies of notice at least 10 days before the day of hearing shall be equivalent to mailing. If the testator daw o yung gumagawa ng will or yung namayapa asks for the allowance of his own will, notice shall be sent only to his compulsory heirs. Ayun. Doon lang daw sa mga itinakdang tagapagmana. Compulsory heirs, like ang halimbawa niyan yung anak. Diba? Hindi mo pwedeng i-disinherit yung anak mo. Ang mga anak mo ay yung compulsory heir. Unless may ginawa sila na masama sa'yo na nakasaad sa batas na pwedeng maging ground para hindi mo sila pamanahan. Kunwari, pinagtangkaan nila yung buhay mo. At marami pang ibang grounds. Pwede natin pag-aralan yan next time pag nahanap ko yan. Section 5, proof at hearing. Di ba proof of hearing to? Oh, proof at hearing. Basahin nila natin nakalagay. What's sufficient in absence of contest? O ibig sabihin, wala raw nag-contest dun sa will. At the hearing, compliance with the provisions of the last two preceding sections must be shown before the introduction of testimony in support of the will. All such testimony shall be taken under oath and reduced to writing. If no person appears to contest the will or to contest the allowance of the will, the court may grant allowance thereof on testimony of one of the subscribing witnesses only, if such witness testify that the will was executed as is required by law. So kung wala naman daw nag-contest na peke yan o mayroong anomalya yan, isang subscribing witness lamang. Ibig sabihin yung nagpirma doon, nakapirmang witness ng pag-execute ng will, pwede na yun. Kasi wala namang wala namang conflict, ganun. In the case of a holographic will, it shall be necessary that at least one witness who knows the handwriting and signature of the testator explicitly declare that the will and the signature are in the handwriting of the testator. Kung wala man daw ganon, in the absence thereof, any competent witness, and if the court deem it necessary, expert testimony may be resorted to. O baka pwede siguro, usually sa mga nag-aaway na partidos lamang naman nagpapatawag ng mga NBI, yung mga handwriting expert. Yan. Section 6, proof of lost or destroyed will. Certificate thereupon. Yun ang pag-uusapan dito. No will shall be proved as a lost or destroyed will unless the execution and validity of the same be established and the will is proved to have been in existence at the time of the death of the testator, or is shown to have been fraudulently or accidentally destroyed in the lifetime of the testator without his knowledge, nor unless its provisions are clear and distinctly proved by at least two credible witnesses. When a lost will is proved, the provisions thereof must be distinctly stated and certified by the judge under the seal of the court, and the certificate must be filed and recorded as other wills are filed and recorded. Section 7, tatalakayan yung proof when witnesses do not reside in the province. If it appears at the time fixed for the hearing that none of the subscribing witnesses, para matutumba na naman to, yon, none of the subscribing witnesses resides in the province, but that the deposition of one, o yung pagsisalaysa ng isa, or more of them can be taken elsewhere, the court may, on motion, direct it to be taken and may be authorized a photographic copy of the will to be made and to be presented to the witness on his examination, who may be asked the same questions with respect to it and to the handwriting of the testator and others as would be pertinent o nakakasapat na and competent if the original will were present. Pwede pala yun. Section 8, proof when witnesses, tama ba yung nakasulat niya rito? Proof when witnesses are dead. Dapat may R to eh. Or insane or do not reside in the Philippines. Yun ang tatalakayan niya. If it appears at the time fixed for the hearing that the subscribing witnesses are dead or insane, or that none of them resides in the Philippines, the court may admit the testimony of other witnesses to prove the sanity of the testator and the due execution of the will. And as evidence of the execution of the will, it may admit proof of the handwriting of the testator and of the subscribing witnesses or of any of them. Tungo tayo sa Section 9. Grounds for disallowing o para hindi payagan ang validity ng isang will. Ito yon, the grounds. Letter A, if not executed and attested as required by law. Letter B, if the testator was insane or otherwise mentally incapable to make a will at the time of his execution. Letter C, if it was executed under duress or the influence of fear or threats. Kunwari, tinakot ng mga salbahing anak, papatayin kita pag hindi ako yung nakapagmana mo dyan. Mga ganun-ganon, ha? O ng kapitbahay na salbahe. Letter D, if it was procured by undue and improper pressure and influence on the part of the beneficiary or of some other person for his benefit. Baka naman sabi ng anak, kung papakamatay ako pag hindi ako yung nagmana sa'yo. O kaya yung kabit niya, kailangan tagapagmana mo ako. Ha? Hindi pwede sa anak mo mapunta lahat yan. Ha? Laki ng hirap kung masahihin ka. Ayun. That is undue and improper pressure, ha? Letter E, if the signature of the testator was procured by fraud or trick, yung nilinlang, and he did not intend that the instrument should be his will at the time of fixing his signature thereto. Kunwari, nung pinapirmahan niya, gumawa pala ng peking chorba-chorba yung magulang na kasama niya, yung salbahing kasama, tapos pinirmahan niya. Pero pinirmahan niya yun, not intending na maging will niya yun. Punta tayo. Section 10, contestant to file grounds of contest. Anyone appearing to contest the will must state in writing his grounds for opposing its allowance to serve a copy thereof on the petitioner and other parties interested in the estate. Section 11, subscribing witnesses produced or accounted for where will contested. Yan ang pag-uusapan. If the will is contested, all the subscribing witnesses and the notary in the case of wills executed under the Civil Code of the Philippines, if present in the Philippines and not insane, must be produced and examined, and the death, absence, or insanity of any of them must be satisfactorily shown to the court. If all or some of such witnesses are present in the Philippines but outside the province where the will has been filed, their deposition and salaysay nila must be taken. If any or all of them testify against the due execution of the will, feeling nila, hindi tama yung pag-execute ng will, or do not remember having attested to it, or are otherwise of doubtful credibility, the will may nevertheless be allowed. Pwede pa rin daw payagan kung the court is satisfied from the testimony of other witnesses and from all the evidence presented that the will was executed and attested in the manner required by law. Yun lang naman ang kailangan eh. Laging manner required by law. Sapat na yun. If a holographic will is contested, the same shall be allowed if at least 3 witnesses who know the handwriting of the testator explicitly declared that the will and the signature are in the handwriting of the testator, yung gumagawa ng will. In the absence of any competent witnesses and if the court deemed necessary, expert testimony may be resorted to. Ito yung mga NBI, yung mga handwriting expert. Yan Section 12, proof where testator petitions for allowance of holographic will o para payagan yung holographic will. Ano ba yung holographic will na yan? Alamin nga natin. Sandali, Google natin. Kanina will lang. Ngayon may holographic na. May ibig sabihin ng holographic na yan. Holographic will. Ano ibig sabihin? Hanapin natin. Ito. Sabi niya, ayon sa Wikipedia, a holographic will or holographic, Kapampangan? Holographic, Kapampangan, tas holographic. Sabihin natin holographic will is a will and testament which is a holographic document. Example, it has been entirely handwritten and signed by the testator. Traditionally, a will had to be signed by witnesses attesting to the validity of the testator's signature and intent. But in many jurisdictions, holographic wills that have not been witnessed are treated equally to witnessed wills and need only to meet minimal requirements in order to be probated o yung maalaw. Di ba? Parang di ko naman naiintindihan, holographic will. Parang, ayon doon sa binasa natin, walang ginawa siya ng walang witness na nakapirma doon sa will na yun. Sige, tuloy na natin, binabasa natin. Where the testator, Greenmaker Waste Channel. Thank you, Greenmaker. Have a blessed day. Section 12, proof. God bless you, Greenmaker. You are awesome. Proof. Where testator petitions for allowance of holographic will. Where the testator himself petitions for the probate of his holographic will and no contest is filed, the fact that the affirms that the holographic will and the signature are in his own handwriting shall be sufficient evidence of the genuineness and due execution thereof. If the holographic will is contested, the burden of disproving the genuineness and due execution thereof shall be on the contestant, the testator to rebut the evidence for the contestant. Okay. Section 13, certificate of allowance attached to proof of will to be recorded in the office of registered deeds. Okay. That's good. Have a good night, Greenmaker. Good night. Please take a nap. Okay. Have a safe dream. Okay. If the court is satisfied upon proof taken and filed that the will was duly executed and that the testator at the time of his execution was of sound and disposing mind and not acting under duress, menace, uy, Green, hey, you're a menace, and undue influence or fraud, a certificate of its allowance signed by the judge and attested by the seal of the court shall be attached to the will, and the will and certificate filed and recorded by the clerk. Attested copies of the will devising real estate and of certificate of allowance thereof shall be recorded in the register of deeds of the province in which the lands lie. Okay. Magtungo na tayo sa Rule 77. Oh, that's great. Thank you for being bored. Okay, this is not for you, but thank you for commenting. I appreciate it, Greenmaker. I love you so much. Okay. Rule. Wow. Okay. Wow. Oh my goodness, Greenmaker. My device has been tumbling. Okay. For whom? It's for Pernan and it's not for you. But it's okay. It's okay, Greenmaker. You may listen if you want to learn something. Rule 77. Allowance of will proved outside of the Philippines and administration of estate thereunder. Section 1. Will proved outside the Philippines may be allowed here. Wills proved and allowed in a foreign country according to the laws of such country may be allowed, filed and recorded by the proper court of first instance in the Philippines. Section 2. Notice of hearing for allowance. When a copy of such will and of the other or decree of the allowance thereof, both duly authenticated, are filed with the petition for allowance in the Philippines by the executor or other person interested, the court having jurisdictions, such court shall fix a time and a place for the hearing and cause notice thereof to be given as in case of an original will presented for allowance. Okay. Section 2 po yun, ha? Okay. Wala na yung nagko-comment, oh. Section 3. When will allowed. End the live. So boring. Then why the fuck are you here? You stupid idiot. When the will allowed and effect thereof. Ayan. If it appears, so many stupid people. If it appears at the hearing that the will should be allowed in the Philippines, the same shall allow it, and a certificate of its allowance signed by the judge and attested by the seal of the court, to which shall be attached a copy of the will, shall be filed and recorded by the clerk, and the will shall have the same effect as if originally proves and allowed in such court. Oh yeah, to those who are listening but is very stupid. Okay, you're listening here, you're bored, but you are here. If you are here, then treat this channel as ASMR channel. If you don't like it, then you can go fuck yourself. Nice one, Greenmaker. I love you. All right. Section 4. Estate, how administered. When a will is thus allowed, the court shall grant letters testamentary or letters of administration with the will annexed, and such letters testamentary or of administration shall extend to all the estate of the testator in the Philippines. Such estate, after the payment of such debts and expenses of administration, shall be disposed in according to such will, insofar as such will may operate upon it, and the residue, if any, shall be disposed of, as is provided by law, in cases of estates in the Philippines belonging to persons who are inhabitants of another state or country. Magtungo tayo sa Rule 78. Letters testamentary and of administration, when and whom issued. So yun po ang pag-uusapan natin dito. Section 1. Who are incompetent to serve as executors or administrators. Sabi rito, no person incompetent to serve as executor or administrator who, letter A, is a minor. Hindi pwede yung minor. Letter B, is not a resident of the Philippines. And letter C, is in the opinion of the court unfit to execute the duties of the trust by reason of drunkenness. Yan, si drunkenness. Hey, drunkenness. Improvidence, or want of understanding or integrity, or by reason of conviction of an offense involving moral turpitude. Section 2. Executor of executor not to administer estate. Sabi niya rito, the executor of an executor shall not, as such, administer the estate of the first testator. Yan, very clear, ha? Very clear. All right. Section 3. Message retracted. Stupid. Section 3. Married women may serve. Sabi rito, a married woman may serve as executrix or administratrix, and the marriage of a single woman shall not affect her authority so to serve under a previous appointment. Section 4. Letters testamentary issued when will allowed. When a will has been proved and allowed, the court shall issue letters testamentary thereon to the person named as executor therein, if he is competent, accepts the trust, and gives a bond as required by these rules. Okay? Section 5. Where some co-executors disqualified, others may act. When all of the executors named in a will cannot act because of incompetency, refusal to accept the trust, or failure to give bond on the part of one or more of them, letters testamentary may issue to such of them as are competent, accept and give bond, and they may perform the duties and discharge the trust required by the will. Section 6. When and to whom letters of administration granted. If no executor is named in the will, or the executor or executors are incompetent, refuse to trust, or fail to give bond, or a person dies intestate, administration shall be granted. Letter A, kanino ibibigay? Kanino daw i-grant ito? Letter A, to the surviving husband or wife, as the case may be, or next of kin, or both, in the discretion of the court, or to such person as such surviving husband or wife, or next of kin, requests to have appointed if competent and willing to serve. Letter B, if such surviving husband or wife, as the case may be, or next of kin, or the person selected by them, be incompetent or unwilling, or if the husband or widow or next of kin neglects 30 days after the death of the person to apply for administration or to request that administration be granted to some other person, it may be granted to one or more of the principal creditors. If may be granted to one or more of the principal creditors, if competent and willing to serve. Letter C. If there is no such creditor, walang pinagkakautangan, na competent and willing to serve, it may be granted to such other person as the court may select. So may iwan na yung sa korte. It is the court who will select if no executor is named in the will. Again, the court will select if no executor is named in the will, or the executor or executors are incompetent, refuse the trust, or fail to give the bond, or a person dies intestate, and administration shall be granted. Yun. Sa mga nabanggit natin, ha? Rule 79. Opposing issuance of letters testamentary. Petition and contest for letters of administration. Section 1. Opposition to issuance of letters testamentary. Simultaneous petition for administration. That is the topic of the whole Section 1. Sabi niya rito, any person interested in a will may state in writing the grounds why letters testamentary should not issue to the persons named therein as executors or any of them, and the court, after hearing upon notice, shall pass upon the sufficiency of such grounds. Period. The petition may at the time be filed for letters of administration with the will annexed. Okay. Section 2. Contents of petition for letters of administration. A petition for letters of administration must be filed by an interested person and must show so far as known to the petitioner that letter A, papakita niya yung jurisdictional facts. Letter B, the names, ages, and residences of the heirs and the names and residences of the creditors of the decedent. Letter C, the probable value and character of the property of the estate. Letter D, the name of the person for whom letters of administration are prayed. Kanino ka ba para saan ba yung letters of administration? Para kanino mo ba yan hinihiling? But no defect in the petition shall void the issuance of letters of administration. Section 3. When petition for letters of administration is filed in the court having jurisdiction, such court shall fix a time and place for hearing the petition, and shall cause notice thereof to be given to the known heirs and creditors of the decedent, and to any other persons believed to have an interest estate in the manner provided in sections 3 and 4 of Rule 76. Section 4. Opposition to petition for administration. Any interested person may, by filing a written opposition, contest the petition on the ground of the incompetency of the person for whom letters are being read therein, or on the ground of the contestant's own right to administration, and may pray that letters issued to himself or to any competent person or person named in the opposition. Section 5. Hearing and order for letters to issue. At the hearing of the petition, it must first be shown that notice has been given as herein above required, and thereafter the court shall hear the proofs of the parties in support of their respective allegations, and if satisfied that the decedent left no will or that there is no competent and willing executor, it shall order the issuance of letters of administration to the party best entitled thereto. Section 6. When letters of administration granted to any applicant, letters of administration may be granted to any qualified, though it appears that there are other competent persons having better right to the administration, if such person fails to appear when notified and claim the issuance of letters to themselves. So letters of administration daw may be granted to any qualified applicant. Doon na tayo sa Rule 80, the Special Administrator. Total, ang pinag-uusapan natin, sinimulan natin ngayon yung special proceedings. It is only fit that Rule 80 talks about the Special Administrator. Section 1. Appointment of Special Administrator. When there is delay in granting letters testamentary or of administration by any cause including an appeal from the allowance or disallowance of a will, yun daw korte or the court may appoint a special administrator to take possession and charge of the estate of the deceased until the questions causing the delay are decided and executors or administrators appointed. Section 2. Powers and duties of special administrator. Such special administrator shall take possession and charge of the goods, chattels, rights, credits, and estate of the deceased, and preserve the same for the executors or administrator afterwards appointed, and for that purpose may commence and maintain suits as administrator. Kasi nga special administrator siya ang nangangasiwa. Okay, ito yung mga powers niya and duties. He may sell only such perishable and other property as the court orders sold. A special administrator shall not be liable to pay any debts of the deceased unless so ordered by the court. Section 3. When powers of special administrator cease. Transfer of effects at pending suits. Yun ang pag-uusapan. Kapag daw ang letters testamentary or of administration are granted on the estate of the deceased, ibig sabihin, nagpetisyon ka ng letter of administration, ginrant ito ng korte doon sa ari-ari ang naiwan nung namayapa. The powers of the special administrator shall cease, and he shall forthwith deliver to the executor or administrator the goods, chattels, money, and estate of the deceased in his hands. The executor or administrator may prosecute to final judgment suits commenced by such special administrator. Ayan na. Okay, so may nag-grant na. Kumbaga, may nag-grant na. Mawala na yung nag-grant yung letters testamentary, may ibang mga ngasiwa, mawala na yung obligasyon o yung duty ng special administrator. So ayan, doon po nagtatapos ang special proceedings na 72 hanggang rules of court po yan, matatagpuan Rule 72 hanggang Rule 80. Marami po tayong babasahin. We will read so much more. And parang ito na yung online audiobook, o di ba? Para hindi na kayo, you will no longer buy rules of court, especially para sa mga ordinary person na katulad ko who are interested in listening or maybe hopefully ma-explain ko ng konti yung batas. So yun po yung special proceedings. Marami pa pong ano yan. Marami pang rules on special proceedings na babasahin tayo. So hopefully, muli nyo akong sasamahan dito sa isa na namang episode na In Layman's Terms. So thank you and God bless you.